Hello, I'm Ann Wells, and welcome back to segment number 3 of the Bar Winners Performance Test workshops. Today's our third segment on the performance tests. Hopefully by now they're starting to feel a little more comfortable for you. Although, as I alluded to at the end of segment 2, this one's a little bit different than the ones we did before, but not necessarily any harder. Again, the performance exam tests your ability to read a problem, think it through, and apply the law from the closed universe library in the format requested. The key to doing that isn't memorizing the law. In fact, you don't have to know the law for this part of the bar exam. The key is organizing the information and timing, making sure that you get it done. The more practice you do, the better you become at it. Getting it done in time is difficult, but the more you do it, the more likely you are to be able to get all the way through and finish. But you've got to practice the performance exams until they become second nature for you. So, as before, we've talked about creating 2 documents to help you organize the material and set you up to write. We have the roadmap, which is the structure of everything, the structure of your argument and what you're going to write down on paper. And then you have the outline, which is essentially everything from the file that you're going to need in your roadmap. So essentially what happens, you start with a basic roadmap, kind of an idea of what you think the issues are and where you're going to go. Then that roadmap informs your outline as you read through the file. You then take the information from the outline, move it into the, organize it into the roadmap, and then you're ready to write. So we're going to walk through performance test number 3. We're going to walk through a case called State versus Dolan, and talk about how to create parts of the outline and the roadmap for that. So, but before we do that, again, I want to review the performance test strategy and approach and timelines. We've talked about these before, but I think it's important to make sure that we're all on the same page every time we approach them. Again, you have an hour and a half to complete the task at hand. You are doing this task in a much shorter time frame or condensed time frame than you would in the real world, which is why it's incredibly important to make sure you organize it and watch your time to make sure that you get it all done. So essentially, again, we've broken it down into 4 different steps. The first step is a preliminary organizing and outlining by looking at the table of contents, general instructions, the the task memo to give you your roadmap, and a really quick skim of the file. That shouldn't take you more than 5 minutes or so, and the key here is that it is skimming the file. You're not going to start reading cases, you're not going to read the file, you're just going to see what's in there, and then you're going to focus on the roadmap, on the task memo to come up with your roadmap. Once you have the roadmap, the next 2 steps are reading the library and creating the outline, which is again pulling all the information out of the cases, out of the statutes, and out of the file, and creating a document which you can then use to transfer into your roadmap in a more detailed way to set you up to write. So that part of the process should take you should schedule about 45 minutes. And then at the second half of the hour and a half period, or the second 45 minutes, that's when you're going to be writing. So it's important that you watch the time and then you make sure that you get through all the steps. So let's talk briefly in the context of the Dolan case about the pre-writing, organizing, and outlining stage. Again, this is the quick overview followed by the roadmap. So the first thing you'll do is skim the table of contents and the general instructions and quickly flip to the library. So this tells us that we have in the file the memorandum to the applicant, which is essentially the task memo. There's also a memorandum regarding closing arguments for bench trials, which is going to be a supplement to the task memo. We'll talk about this more, but because this is going to be a closing argument rather than an objective memo, the bar examiners have actually given you some additional guidance that you'll find through there. And then for purposes, just as we're skimming, you can see that there's a trial transcript, which looks to be about 15 pages. Then if you quickly flip to the library, you'll see that you have a page of statute selected provisions of the Columbia Penal Code and one case, State versus Jones. So the next thing that you'll want to do, and again, this is going to be quickly, as they may likely be the same each time, but in the event they're not, you need to read them in case any of this has changed. And that's looking at the page of instructions. The sheet that says State v. Dolan instructions. Again, it tells you in paragraph 2 the jurisdiction is Columbia. That's important because not all cases in the library may in fact be Columbia cases. As you know from last time, doing the TP case, there was a case from Oregon that was persuasive authority, not binding. So make sure that you always check the jurisdiction, know what jurisdiction you're in and what jurisdiction your cases are from. So again, they're using the same procedure. As far as citing cases, you can use abbreviations and you can omit page cites. So you don't need to waste your time or spend any time trying to create blue book cites out of these Columbia regulations and Columbia cases. You can just put the name of the case and that's all you need. You don't even need an internal page cite. So lastly, they remind you here that you should spend approximately, in fact the bar says at least 90 minutes reading and organizing, half of the 90 minutes reading and organizing and the other half writing. So there again, their recommendation is the same as ours. So again, so once you finish with the instructions, you're going to flip to the task memo, which is the next document, and see what it's asking you to do. Again, as you read the task memo, you have to pay attention to what they're asking you to do. What document are they asking you to create? So far we've done a couple of objective memos. As today's example shows, some formats may be less straightforward than a memo. It could be as it is here, a closing argument, it could be an opening argument, it could be a discovery plan, but you need to focus on what they're asking you to do. And again, when you have something that's different than a regular memo, think about who your audience is and whether it's persuasive or objective. Generally to opposing counsel or the court, it's usually going to be persuasive, which means that you tell everything from your point of view. So as you look at the task memo, always ask yourself who's the audience and what format they're asking you to do it in. And then follow the directions. Again, to the extent that there is more than one task within the task memo, if there's no weight, you can assume they're 50-50. If they are weighted differently, then you want to make sure that your emphasis is appropriate. So, as I'm going to do a number of times in today's workshop, I'm now going to ask you to turn off the tape and to look at some of the documents and work with them, and then when you've done that, to turn the tape back on and we'll proceed. So right now what I want you to do is take a quick few minutes and read the task memo. Okay? Okay, turn off the tape, read the task memo carefully, think about what it is telling you, what you can glean from it, and then we'll come back and talk about it. Okay, we're back. So hopefully if you read the task memo carefully, it actually tells you quite a bit. There's a lot that you can glean from it. First off, it tells you you are the state attorney prosecuting Dolan for possession of meth and marijuana, and possession with intent to distribute meth and marijuana. So we've got our issue framed already, I think, and you're going to be thinking, okay, it's likely going to be, are these charges appropriate, or I'm going to be persuading the court that these charges are appropriate. The second paragraph, after a little bit of surplus language that, or extra backstory about why you're in the predicament you're in, the last line of the second paragraph says, I will present the closing argument, but I want you to prepare a draft of that closing argument for my review. So you've now been told your assignment here is to draft a closing argument. Don't panic. Okay? Don't go, oh, I didn't take trial ad, I don't know how to do this. The bar examiners are actually going to walk you through this with the instructions in the task memo and the secondary memo to this. But again, one of the first thing that should key you into is that this is going to be a persuasive piece. If you're writing a closing argument, you're advocating for your position, your point of view. The third thing that we get from the task memo is the next sentence, the first paragraph first sentence of paragraph 3 says, please write out the argument exactly as you would give it if you were presenting it. Okay, so they just told you what they want you to do, what it needs to look like. And that includes that you're going to be addressing it to the court. This is an opening argument. So you're not setting this up as a memo. You're going to be starting it likely with an introduction of yourself and addressing it to the court. So this is part of the make it look like they want you to make it look. And that's an important hint on that. They then do something actually kind of interesting that they don't always do in the task memos. In the fourth point in this says it might be helpful to read the library first. You need to understand the elements of the charges in order to understand how the witness testimony establishes those elements. So, and this is what I have said previously in the last 2 workshops, is I generally find it's a good idea to read the library first, because it then focuses you in on what facts to look for, what facts are going to be important. And in fact, the bar examiners are telling you the same thing right here. Again, it's important to read the library first, understand the elements, and then figure out how the facts meet those elements. So, and the last point then is, the last sentence is, follow the guidelines contained in the office memo on closing arguments bench trials. Again, finally, don't panic. It's going to give you some guidelines on how to do a closing argument. And let me give you a hint here. If you get something besides a memo that has these sort of additional guidelines or specific things that they want you to do, don't panic, and in fact, pay attention and read the guidelines closely, because the guidelines will often structure it for you. They will break it down and tell you how they want to do it, or how they want you to address it, in a way actually that just telling you to write a memo doesn't. So they give you those additional guidelines for a reason, and follow them. So, and in fact, the guidelines are a good thing. So it gives you a structure. So I'm going to have you now turn off the tape again, and I want you to read through the guidelines so we can see the type of thing that they tell you. Read it carefully, and we'll come back and talk about it. So turn off the tape and come back when you're done. Okay, we're back. We are now going to work our way through the guidelines on closing arguments, bench trials. As I said before, you stopped to read this, and now you can tell by having read it, they're telling you what to do and how to do it. So you need to follow it. Okay? I'm going to highlight a few of the important things because there is quite a bit in there. First, they're telling you in the very first sentence, your closing argument should begin with an understanding of the elements of the crime that apply to the facts of the case. They're telling you to apply the facts to the elements, so the elements are going to give you a roadmap. You've got two crimes here. One is possession, and the second is possession with intent, and you're being asked to prove both of them. So, they then tell you that the legal authorities will provide the framework for your closing argument, and the argument must show how the evidence admitted during the trial meets the elements. So again, they're asking you, what is the rule for what do we have to establish? And then explain what has to be established, and then explain how the facts meet that. It's actually essentially telling you to do it, and for each of the two alleged crimes, it's asking you to do a persuasive IRAC. So this sets forth how the facts and the elements mesh together. It then goes on at the end of the first paragraph to remind you that this is not a legal memo or an essay, which is telling you it's persuasive. But they also give you some guidelines that says it's based on the evidence presented, not histrionics or personal opinion. That's important because they're telling you they really want to see you tie the evidence, tie the facts with the law. Don't just, as it says, engage in histrionics or over-the-top hyperbole. Match the facts to the law. So, then the last paragraph on that page tells you, essentially gives you a roadmap on how to address the issues, what they want you to do. And again, it says address each charge separately. For each charge, state the elements that are required for the conviction. Argue that the evidence establishes each element beyond a reasonable doubt. And draw reasonable inferences from the evidence to support your position. That's telling you that you may have to use some creativity with some of the facts or to link them to the elements. But they've essentially just given you a basic roadmap. So, and the last, by the way, the last point on that, and this is an important one, is it says never hold back any argument, assuming you will have a second opportunity to make it in rebuttal. I think the reason that they put that on there in the instructions is they're intending for you to sort of anticipate or rebut counter arguments. Normally you might wait for the other side to make their argument and then raise it on rebuttal. They're saying don't hold back. So if you think that there's a weakness in your case or an argument that they're going to make, you need to rebut it or address it in your closing argument. So with that in mind, in that guideline, remember we're using two different charts here. One is the outline of the information, and the other piece is the roadmap, which is the structure of what we're going to be writing. So they have essentially given you a roadmap. It says address each charge separately. Okay, so what do we have? We have two charges, right? We have possession. We know he's already charged with possession of meth and marijuana, and possession with intent to distribute. Both the meth and the marijuana. So for each charge, state the elements that are required to get a conviction. So for right now, I'm just gonna roadmap. We'll erase this later, but when we fill it in, when we know what they are. But element number one, we're gonna have the rule or an explanation. We're gonna have facts, and we're gonna have a conclusion. And then if there's likely an element number two that goes into what has to be proven. So you're going to have the rule of the element, you're going to have facts that support it, and you're going to have conclusion. And the same thing over here. But I put this up right now so that you'll think about it. Okay, so this is facts using evidence. Okay, and the reason I put it up like this is because hopefully the structure of this just became apparent. This is an IRAC, okay? Element number one for possession means X. Here, the evidence shows that Dolan did X, Y, and Z. Therefore, element one is met. Element two, and so on. And then you'll do the same thing with possession. Now we've got to figure out, we've got to read the statute and the cases to figure out what the elements were proving, but this is the structure that you should be thinking about as you're reading from the library. Again, this is active reading, thinking about what you're going to need to show, and let that inform your what you're putting in your outline. So, with that preliminary roadmap in mind, you can now read the library and outline the law. Remember again that the roadmap is going to inform how you read the statutes and the cases so that you can focus on the most important part. I can't reiterate enough that you don't have the luxury of time to perform these tasks. You have to be quick and hone in on what's important. For purposes of cases, that's usually the basic facts, holding, and reasoning that are applicable to your issue. You're not doing case briefs. You're not outlining cases. And again, don't just highlight don't just read the cases and highlight. You're going to have to pull the information out of the cases because you won't be able to find it again if you just highlight. You'll be flipping back and forth and not really getting to the information. So what you're going to do on your outline here is take notes of the keywords, the relevant facts, the law of the case. Keep them short. It can be bullet points or facts, holding, reasoning, and think about what issue that they relate to. And as you recall, remember the setup on this is statutes, cases, and then our facts later from the case file. And again, once you have these, you're going to merge them together and put them onto your roadmap. So what I'm going to ask you to do now, again, is turn off the tape, take a few minutes to read the statutes, and then the one case, State versus Jones, and let's see what we can figure out from that. So turn off the tape and come back when you've had an opportunity to digest these cases. Okay, we're back. So, what do we have in our library here? We have, looks like we have 3 statutes and 1 case. Although, as you'll see, there are cases within the case that I think we need to highlight. But let's deal with the statutes first. Again, the framework on this is we need to know whether we can prove possession and possession with intent to distribute. Having read the cases, the one case and the statute, it should actually become clear that most of the issue seems to be with whether you can show possession with intent, and the possession issue is perhaps a little simpler to meet. So keep that in mind as you move forward to, as you're writing and such, to make sure that you're not overly analyzing this one and then not getting to the second one. So if you look at the library, again, it gives us 3 statutes, one of which is actually 4 statutes. They did something interesting here. They started, if you look at, flip to the statutes, it starts by giving you definitions. What I would suggest in this particular instance is I would start with the 3 shorter statutes, read them first, and then see which one of these definitions sort of fits into what we're talking about. Because otherwise you may end up writing down a lot more than you need to from the section 200. So I would start with section 840, code section 840, which gives us the elements of possession. You could put it here. You also might be able to put it directly into your roadmap, because it's pretty clear that section 840 is says it's unlawful for any person to possess. So actually unlawful for any person to knowingly possess a controlled substance. Okay, so this actually just gives you your 3 elements, right? So as you read the case facts, or the case file, you're going to say, okay, what does knowingly possess controlled substance mean, and what facts are going to help meet each of those. You can also go directly to section 841 over here, which is unlawful to knowingly manufacture, distribute, possess, or dispense to manufacture, distribute, possess, or dispense sorry, I did that wrong. Distribute, dispense, or possess with intent to distribute, Okay? So you have to read that carefully. So it's manufacture, distribute, dispense, or possess with intent any controlled substance. So again, we can see the difference here as possession is as it seems, just possessing, where here you're going to have to show you possessed it or manufactured or distributed it with the intent to distribute. So mere possession is not enough for possession with intent to distribute. You have to have intent. Section 875 gives us, and I'm putting it here, it can go in both of those. It essentially says that both meth and marijuana are controlled substances. So section 875, that's 875.13, I believe, for meth is 38 and marijuana is section 13. Same thing. So your first element that you're going to be talking about is it a controlled substance? And we've got a statute that says it is. There may be more that you can add, but that's preliminary where we are. Okay? So now we go back to the definition section, 200, and we realize that both of these statutes require for a person to knowingly possess or a person to knowingly manufacture, distribute, or possess with intent to distribute a controlled substance. So we have to figure out what does knowingly mean. And we find that in section 200, which tells us that knowingly means aware is either aware or from the circumstances or a high probability that they're aware. Okay? So again, knowingly then would be section 200, definition, and section 200, the definition. So it's already starting to come together. Obviously, there's going to be some other issues. Certainly here maybe so whether they actually possess, but here I think the big issue you can already tell is going to be the intent to distribute. And that's before we've even read the cases, or read the case. So let's look at the case. We have one case, but as I said, it has cases within the case, and we need to think about those. So, so let's look at State versus Jones. Okay, if you look at the second page of the case, they start to, they tell you a couple of things. It says, the paragraph that starts, "We disagree with the government." It says, "It is true that the intent to distribute may be established by circumstantial evidence," and then it lists a number of things, okay? A number of factors that may be considered. Again, I love in cases where they give you lists of things that you can consider or that courts can consider, because they're giving you a roadmap or a highlight or a ding, ding, ding to say, okay, these are things I'm going to look for in my facts. So first they said, and now we're talking about intent to distribute. Okay, so this is factor 2. Intent to distribute, and Jones says that intent may come from circumstantial evidence. Okay, I've got this here as a rule. But I'm also going to now put the balance of it over here, where it says intent can come from circumstantial evidence. Circumstantial evidence can be things like, and then they give you the list, and you want to get the list somewhere that you can refer back to it, because again, this is your roadmap for how your facts may or may not match up to it. So you're going to be looking at things like quantity. This is from the list on the second page. Purity, firearms, cash, and packaging. And these are some of the things that they're saying, these are factors or circumstances. Okay? So, when you go through the trial transcript, you're going to pull out the important and relevant facts that match up to some of these factors. So, but before we get to that part, we need to walk through the Jones case a little bit more. Again, I'm not going to go through every single thing. You guys will have these handouts to look at, but what happened in the Jones case? Look at how the court applied these factors. They went through a couple of things. They said, first off, that intent may be inferred. Intent may be inferred from large quantities. Okay, and that small quantities is not enough alone. Again, this matches your first factor up there. Then they also looked at the purity, and they said 47% purity by itself, standing alone, was not sufficient, but it was a factor that they looked at. So what are you starting to see? It sounds like we're going to have to, and again, think about this as you read our facts, you're going to have to stack these. Okay? One factor alone is not going to be enough, so you're going to need to find things to back up the point that you want to make. And then the court said, in this case, it said, here, they didn't have sufficient evidence to convict in the Jones case because there was, so we've got no conviction because there was no distribution material, and there was also, they explained away one rifle as camping or hunting. So in this particular case, the court said that we didn't know for sure that there was enough, that there were enough drugs, and while the purity lent itself to it, there wasn't any distribution materials, there were no packaging materials, therefore there was no conviction. They then bring up a couple of other cases, and when these cases do this, the bar examiners intend for you to look at the cases within the cases and use them as well. So make sure that you make a note of them. It next mentions, the next thing that it mentions is the Ojeda factors, or the Ojeda case, and it distinguishes it, and it says, in the Ojeda, this case is not like, unlike Ojeda, where the court found an intent could be drawn from intent from 7.1 kilos, in this case it was coke, and a purity of 88 to 90%. Okay, so in the Ojeda case then, the court found that when you had quantity and purity, that was enough. Right? But then the court goes on to talk about the White case and the Franklin case. Again, the court said in White, he was convicted, but possessing just a large quantity, 75 doses, wasn't enough alone. 75 doses, so the quantity alone not enough, even though it was a lot. Right? But then they go on to say there were, in that case, packaging and a large amount of money and a revolver. And so that was enough. Okay? So then lastly you would go to Franklin, which is cited in the case, and they said 35 grams, pure 42% was enough without, they go on to say there was not additional evidence, it wasn't packaged, there was no cash, there were no weapons, no nothing. So Franklin was a non-convict. And you want to jot the factors down here. I'm running out of room, but again, you would want to be able to get an idea of what's going to be enough and what's not going to be enough. So, there is some interesting language where it talks about a firearm is a tool of trade for a drug dealer, and gives you some information, additional things you could say about firearms. I would probably highlight that as well, just in case our facts end up showing that in fact this guy had guns. Because here's where we are now. You know now from reading this case the kind of things that you're going to be looking for when you read the file. You're going to be looking at the quantity of the drugs, the purity of the drugs, the firearms, whether the defendant had firearms or not, whether he had any cash around, and packaging. And then you're going to look at any other additional circumstances. Okay? So, what you're going to do at this point now is go through the trial transcript. And again, we've been this case focused purely on, focused for the most part on intent. But if you get to the end of the case, don't forget about simple possession as well. Because the Jones case does talk about simple possession at the end. When the court says, gee, we don't have enough to convict him, but we can still get him for possession, even if we can't get him for possession with intent. And they give you, at the bottom of the page, says the common elements of drug possession and possession offenses are a controlled substance in sufficient quantity and usable form. So they've added to the statute that there has to be sufficient quantity in usable form, that possession, and we get some guidance now on what possession means from this case, and it says it can be physical physical, constructive, exclusive, or joined. And 3, knowledge means that knowledge of the fact of possession and that it's illegal. So you need to have knowledge of possession, and 2, that it's illegal. So now we've got, I think, everything that we're going to get as far as possession. Okay? So we need to know sufficient quantity and usable form, possession meaning physical or constructive, and knowledge of possession and the illegality. Again, so you're going to be looking from the transcripts for things to fill out these different categories. And for here, as you read it, you're going to be looking for facts that fill in these factors. Okay? So, let's, with that in mind, you know the issues, you know the kind of things you're going to be looking for, and you should be really focusing in on those things as you read the facts. So this trial transcript is sort of a bit interesting here, because as you start to flip through it, you've got you'll see that you actually have examination testimony of a number of different witnesses. I think there's probably 5 or 6 of them, and you're going to want to break it down as to what each one is revealing to you. So again, there's 15 pages of it here, so I'm not going to have you go through the entire thing right now. Although, turn off the tape, take a few minutes, review the notes that you have on the particular, each of the particular declarants, and we'll see what we can find for the various elements. So take some time to review the trial transcripts and your notes, and then we'll go from there. Okay, we're back. What I'm going to have to do here is, because we have a lot of facts in this case, because we've got a lot of different witnesses who are telling us different things. So again, if you were running this on paper, what you would do is just run it sequentially down like this. I'm actually going to start here and move it over there just for our purposes. As you go through, and again, if you see the breakdown and you guys have this, if you start doing it, starting with letter A, I come all the way through, on this example, through letter double F. So there's basically 35 different facts from 6 different witnesses. There's also, some of the facts will fit easily into some of these categories that we're talking about. They mention purity, they'll mention firearms, they may mention packaging, but the quantity's kind of hidden in there, but you'll be able to find that from some of the testimony as well. And then the other issue arises because, again, from circumstantial evidence, if you think about the fact that these 6 witnesses all seem like they bought drugs from this defendant with the intention to sell. And I mention that because it doesn't necessarily fit into one of the factors that the Jones case gave us. Okay? But Jones does say that you can imply intent from the circumstances, and here, one of the circumstances we have is that he sold drugs to 5 or 6 different people who then admit that they resold them. And that may, in fact, if you look just at the words of the statute, it's intent to distribute for purposes of resale, and then you have an additional argument that you can make. And that's why here I put Jones' intent may come from the circumstances. So beyond that, I want to just focus in on, for our purposes, although you're going to use everybody's testimony, I'm going to focus just in on the declaration of Atwood. And let's see what we can find out from that. And then after Atwood, the defendant. Atwood starts on what appears to be numbered page 58. Atwood is a detective with the Drug Enforcement Agency. So let's see what, just as an example, what would come from Atwood. The first thing Atwood says is executed a search warrant on Rodney Mack. Again, I'm starting with S because I've got, as you'll see, a number of them prior to that. And that the search warrant for Mack's house, Mack is not our defendant, remember, but he was one of the other one of the other witnesses who did transactions with our defendant. Said they found a 1/4 pound of meth, drug records, and cash. Okay. Next, she says, or B.J. Atwood, we don't know. And anyway, Detective Atwood says they also did a search warrant on Tom Cano, which is another of the witnesses, and there they found a 1/4 pound of meth, which we're told is worth $4,200. Okay, so now, and again, you've also got testimony earlier in the facts that both of these guys bought their meth from our defendant. So now it's starting to look like, okay, he's selling a fair amount of drugs. So then they executed a search warrant on defendant's house. And now we get some good information that we can use. The search warrant found 12 firearms. Are your eyes lighting up? You're like, oh good, we've got the firearms. That's going to go over here. It's one of our factors. 40 grams of meth. Wrapped in a can. And 150 yards from the house. Like, oh, okay. What do you think that goes to? 150 yards from the house. Is that possessing? You're going to have to argue that it is. And there was some drug paraphernalia. Okay. They also found 73 pounds of marijuana. I don't know about you, but that seems like a lot of marijuana to me. So I think we're starting to see, okay, what argument you're going to make from that. It was in 6 large bags in 55-gallon drums, sorry. And then it was locked with a key that they found in the house. Okay? And all the evidence was admitted. Okay, so that's Atwood. Oh, they also, actually Atwood gives us some additional facts. The meth was sold, meth is generally sold in a 1/4 gram unit. 40 pounds would not be for personal use. This is Atwood testifying. So, again, they're just telling you 40 pounds is a lot. As is 73 pounds of marijuana. Then they throw in a little problematic fact that you need to acknowledge, which was some of it, about 20%, was water damaged. So what does that go to? Probably goes to sufficient quantities in a usable form, right? You're going to have to deal with the 20% water damage. Okay. So that then is Atwood. The last facts that I'm going to highlight and just have you again think about how you would use them are Dolan is our defendant, and he testifies to a couple of things. First, he says, they're not my drugs. He just denies it. Okay? He said they could be anywhere because he lives in a rural area. He blames Gardner, which is another one of the witnesses. So we'll say blames the other guy. Says his guns are for hunting. In other words, these are all his excuses. And then he admits that he knew meth and marijuana were illegal. Okay, that's good. That's an important fact because that's here. This goes, let's see. Okay, now we have, he admits it was illegal. We've got him on the knowledge. You're going to have to talk about the possession. Let's see. That would probably be V for possession. It was found on his property, and also, yeah. Let's see, 76. Yeah, that's under V. Okay. So, I've kind of moved into how you move it over from here to there, but that's the process that you're going to want to be doing as you're going through these. Okay, but so let's just deal with the possession, the possession elements. First thing is there has to be sufficient quantity in usable form. Well, if you look at our statute, it doesn't say there's no quantity, right? And you'll say, so section 840 just says, essentially, doesn't set forth a quantity, so he has, and in fact, he's still got a lot of drugs. He's got 40 pounds and 73 pounds, so he's got what would arguably be a sufficient quantity for something that doesn't even set it. Usable form, okay, you're going to have to deal with the water damage. Okay, the water damage was under V1. So in any event, you're going to have to deal with the water damage and explain that away. But possession, again, you'll say it was found on his property, buried on his property. And we also will have, when you go through the facts of the other witnesses, they also testify how they bought drugs on his property. So you'd also have witness testimony that he possessed it on his property. Okay, so then we've got sufficient quantity, usable form, possession from being on the property, or testimony that was bought on the property, and that he knew it was illegal. Now you're going to have to deal with his, and this is, I bring this up because at the beginning, remember we said don't hold anything back for rebuttal. So you're going to need to address the fact that he's going to say, they're not my drugs, you know, they could have been anybody's. Okay? So then you're going to need to deal with the counter argument. And again, you may say the weight of the evidence of all these people saying that they bought from him on the property, that the barrel was in fact buried on his property, which makes it kind of hard for somebody else to do it. The key was in his possession, therefore some other dude did it argument is probably not going to work. And then that's it. I think you're done. You're ready. You've got your possession argument here. But see what I said about once you break it down into the elements, what you need to know, then you can slot the facts in underneath. Okay? So you're going to go through the same process with the possession with intent to distribute. And remember, we have these factors: quantity, purity, firearms, cash, packaging. Those are all going to be here with any testimony as to any of this. For example, Atwood tells us that it's not on there, but you're gonna have facts for each one of these. We've got firearms, okay, and that we've got from Atwood's testimony that they found 12 firearms when they searched his when they executed the search warrant. Cash and then packaging. We talk about the packaging. So, as well as there's purity that we have on there, but you've got to match each of the factors up to your facts. But again, they've given you a roadmap for doing that, and which is why I think at the end of the day, even though this one seems initially difficult because it's not a memorandum, it's a closing argument, pay attention, as I've said a couple times, to what they're asking you to do and follow the instructions that they gave you. They gave you the roadmap, they told you what they wanted you to talk about, and all you needed to do was essentially to fill in the blanks. So, again, couple of things when it comes to writing it, and then we'll wrap this up. Again, make sure that you leave yourself enough time so that all of this wonderful information actually makes it onto the paper that you're turning in. Remember also that you want to use headings, and you want to certainly have different separate paragraphs for each one of these, so that the person reading it can go, okay, yeah, they talked about the water damage. Yes, they talked about constructive or possession. They talked about knowledge. Don't put it all in one paragraph. Break it up so that they can find it. Also, here the instructions were to direct it to the judge and to write it exactly as you would a closing argument. So make sure that you are putting it in that form, and at the end, both you want to have an intro with, the state has proven beyond a reasonable doubt that each of these elements is met, and you want to conclude with the same thing. But you want to make sure, again, that you have a conclusion, that you've addressed it to the judge, and you've made it look like what they're asking for. So, with that, I'll leave you one more time with the reminder to practice, 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 and it'll become, hopefully, second nature to you. So, thank you very much, good luck, and just keep swimming.